Cook County just unleashed a malpractice neutron bomb. Even if you don't practice anywhere near Chicago, this case is going to get appealed and the outcome is going to impact everybody. I'll get to what that is here in just a little bit and how it ties into this very unusual case that deals with enforcement from beyond the grave. Stay tuned. Hello again, hope you're all doing well. As you can see, I'm working on an actual studio. I even got my own sound panels. You can't see them, but they're there, so excuse the work in progress. Today's case is all about enforcement from beyond the grave, and normally we chalk this one up to a Aflac trivia video and then move on to the cool stuff. Give it time. But as some of you know, this happened, and we'll get to what that is here in a sec, but let's quickly cover this atypical opinion so you can see why it's all sort of connected. And I say atypical because, well, the husband and wife are both dead. They divorced in 1985. Their MSA requires each to leave half of their estate to the kids when they pass. And a year before the husband dies, he executes a new will that leaves, well, more than half of the estate to his new wife and whatever to the kids. Well, the kids want their money, so they decide to go back to family court to enforce this 50-50 deal. But dad and the new wife, well, they had long since moved to Florida. As a matter of fact, the new wife never even lived in Illinois, and there were probate proceedings underway in Florida when the Illinois enforcement action starts. So the issue is, does Illinois even have jurisdiction to enforce this 50-50 deal, even though mom and dad are both dead? And the primary recipient of the new will has really no connection to Illinois, and stuff's already going down in Florida. Well, both the trial and appellate court say, yes, we can enforce this 50-50 deal, and here's why. As to the enforcement of a posthumous MSA, jurisdiction remains by, and here's a term we don't hear much these days, common law. And under common law, it's indefinite. Yeah, kinda, because if you remember, I covered this case. Money judgments still adhere to the statute of limitations, even if you sneak them into an MSA. Now, as to the new wife having no contacts with Illinois and the Florida-Illinois kind of court battle going on, well, the action in Illinois is not seeking to distribute who gets what. I guess Florida can figure that out. The Illinois action is just to get the kids a money judgment, which they can register in the Florida probate proceedings. Wink, wink, nod, nod. The lesson from all this is you can change a will at any time, but the property divisions in MSAs, well, they're kind of locked in after 30 days. You can't modify them. Putting will terms in an MSA is not something I would normally recommend. I mean, look at this case. 35 years since the divorce, a lot happens. Relationships change, like Telemundo stuff. And hindsight is a cruel mistress. But, and there's always a but, we have this $1 million case in Cook County, and it's probably going to force us to rethink all of this depending on how that plays out. Because I would venture any family law attorney practicing more than just a few years is probably going to be on the hook in some way, shape, or form, and there may not be much we can do to mitigate it. If you don't know, there was a recent trial court judgment that found a lawyer liable for $1 million. Why? Because he failed to predict that a party would come down with pancreatic cancer 2 years after the divorce. As the complaint states, all the warning signs were there, like being fat or, you know, these attributes probably apply to most Americans. I mean, let's face it, compared to the rest of the world, we're pretty unhealthy. Anyways, because the lawyer didn't suggest that life insurance was going to be part of the settlement discussions or demands, and the husband then died, it meant no more child support, and that led to this $1 million malpractice judgment. Now, that case is doing some post-judgment motion practice, but once it's over, it's getting appealed. And if the appellate court upholds the malpractice finding, today's case means a whole lot because, well, if we have to start predicting the future, then here's another section, 503G, because maybe the parent isn't insurable. Well, then gee whiz, I guess we should have forced them to set up a trust or enjoined them from being generous in a will. And don't get me started on section 504F. So we may see a ton of cases like the one I just covered, because folks, I don't think it's gonna upend the practice of family law. At the same time, I don't think ISBA Mutual is gonna wait for the appeals court to figure this one out. Right now might be a good time to see if we can lock in some really long-term rates because I suspect personal injury lawyers are looking at us like it's dinner time. Anyways, that wraps up today. Join us next time as I cover Garbage Day! Yes, an appellate case that barely justifies me using this 14-year-old meme. It's gonna be good because we got a few surprises in that one. If you want a heads up when it drops, you know what to do. Anyways, that's all I have. Thanks for watching.